And now I would like to invite the GDPR panel on stage. And I will quickly introduce the panel leader, Jaap Henk Hoepman, and then give you the microphone. You can take it from there. Jaap Henk Hoepman is a professor in Radboud University, Nijmegen in the Netherlands, as well as affiliated to Karlstad University in Sweden. And as I said before, he has actually a distributed, that I didn't say before, he has a distributed systems background, and then moved into cryptography, but was also affiliated to a law school doing IT law. So happy that he agreed to be the panel leader for this GDPR panel.
I don't need a mic.
Oh, sorry, yeah.
I was mic'd up. At least, yeah,
sure.
It works.
So
excellent.
I'll give the mic to Christian.
Thanks. In nice colors even. Wow, excellent. Thanks, Nick, for the introduction. I would like to thank the MPC Alliance for inviting us to have this panel on GDPR and MPC. And I'm here joined by three experts on the topic. We have Walter van Holst, who already gave an introduction of GDPR. We have Trien Seal from Cybernetica, and we have Christian Rechberger from the University of Graz joining me here. I'll be the moderator. These are my stars. They will do most of the work. And I would like to ask Trien to maybe make a brief introductory statement, and then Christian, and then we'll take it from there, given that Walter already took some time.
Thank you. I guess I have to use this yellow sun sign. Okay. So my name is Trien. I'm a privacy engineering consultant at Cybernetica, and why I've been involved here is probably because we have some real-life deployments of MPC, together with some legal evaluations, both from data protection authorities, as well as researchers, as well as data protection officers in different contexts. And these evaluations to use of MPC in practice, they are actually very diverging across the years. So we've had deployment practice for about 10 years. One of the first times we used real data in MPC was around 2015 in a project called PRIST, which dealt with students and education. So we helped a research institution to find out a correlation between IT students dropping off from university. And used an MPC on the go. We used two types of inputs. So there were data from a public registry about students' education, whether they are actually employed in a university, and there was also another data set from tax authority, so whether they're actually working. And we put those two data together in MPC to find out whether those who are working are actually more potential to drop off from university. And well, the lucky result was that no, there was no correlation. Students, it was just hard to study IT, not because they are working. But what was an interesting learning point here was that already at the time we could actually engage after hard work across more than a year, around 14, 15 months. We could engage real parties from government sector. So 2 administrative databases, 2 ministries of Estonia were involved. And we did have real data processing agreements between them, and also licensing agreement between them and Cybernetica. And we worked out some of the legal requirements that need to be put in place in order to deploy MPCs in practice. And that was a good starting point for me when I entered the company a couple of years later to learn. So what are the legal aspects that need to be taken into account when you set up MPC deployment? And 10 years later, it turns out we're still talking about the same issues and same questions. So apparently things have not evolved too much, but I'm really glad to see that they are still actual, and I would really love to learn more about the different use cases around, so perhaps we can draw some patterns, hopefully, to start learning and accelerating the adoption of MPC in practice in a legal-friendly and privacy-friendly manner. Thanks.
Thank you, Trien. Christian.
All right, yeah, maybe I'll start with a bit of a background. So
Yes,
I'm
please.
the the token technologist on this panel here.
I'm here to support you a little bit.
Of course,
I am a computer scientist.
Of course. Yeah. No, I mean, much of the conference here is technical, and I enjoyed this a lot, and I hope you could also get something out of this here. Yeah, congrats to the organizers. It's really nice to see so much interaction. You usually don't have this at many of these cryptographic technical conferences, so that shows the interest and the excitement about all of that. Yeah, about myself, I'm a cryptographer, professor at TU Graz in Austria since 10 years. I have a history of visiting many academic places, also Microsoft Research before that. Yeah, in my research group, we cover all kinds of cryptographic topics, from foundational work around cryptographic primitives, but also PhD topics on multi-party computation, topics on homomorphic encryption, topic on zero-knowledge proofs, topics on differential privacy. For example, there's even students, one of them is here, Roman, who did main author papers on several of those technologies altogether. So this is a quite unique mix, perhaps. Yeah, this was also the breeding ground for our spin-off that we started like 2.5 years ago. Roman, one of the co-founders, and actually another co-founder, he was Lukas Helminger. He's also the co-author of a paper that we wrote on the MPC and the GDPR, maybe one of the reasons I'm here. So this is the connection to this commercialization efforts here as well. So technology meets subjects like law is definitely important for that area. So yeah, with this spin-off, we started out with like solving hard crypto engineering problems of other deep tech companies, but since a year or so, the strategy is shifting towards making our own scalable, high-impact product in the area of verifiable and private computation for the internet at large. So really with global ambitions. So the idea is to really accelerate development and on the technology side, at the back end, we focus on MPC and zero-knowledge proofs, and that's where the background then leads to this workshop here as well.
Okay, thank you. Walter, any reflections on the last few presentations and the two introductory statements by your fellow panelists?
Well, I tend to complain endlessly about our data protection authority. Given the remark about the Bavarian one, I'm all of a sudden very thankful of ours, because this was a level of ignorance I did not expect. But it meets the stereotype about the Bavarian data protection authority, I sadly also must admit. A few things, given the firm I'm with has been involved with some of Roseman projects, also with some of a competitor of Roseman, and we typically get involved mostly in healthcare, scientific data processing kind of questions, and quite often the question asked to us was more like, look, it looks all nice and fancy, this multi-party computation, but how does this actually help us in meeting our GDPR requirements and the actual big, and that also echoes what the two previous speakers said. The bigger reluctance is more on the side of medical secrecy rules and healthcare law than purely a GDPR thing. That is one thing. And there's one topic that we have not really touched upon so far, but from a GDPR perspective, the governance of your various compute nodes and the protocols you're using, for example, how do you decide among your various organizations, for example, the level of the thresholds, or what analytical questions passing through your various parties are acceptable or not acceptable, and what's the process for that? To me, those are actually the really big challenges in applying this promising technology.
Okay, thank you. We in preparation of this panel, we had a preparatory call. We shared some notes and articles, and one article that was, I think, interesting was a paper by Christian and a few others on multi-party computation in the GDPR, which is really about this topic. And there was one sentence that I thought was like interesting in to sort of like set the stage here, where you say that most effective pets are being neglected to a large extent. Instead, businesses and public authorities choose organizational measures and weak pets, and a major reason for this is the legal uncertainty involving pets. Can you maybe sort of like elaborate a little bit on what made you draw that conclusion? And then I'm sort of curious also by the legal experts here how they could maybe help in resolve that inherent tension there.
So you have to admit I don't remember exactly in which context we wrote the sentence. The paper is already 3 or 4 years old. But I guess this was in the context of still at university before we made this spin-off. We were working in a number of projects, some of them European Union funded collaborative projects, and while doing that, talking to use case providers, for example, talking to companies that were participating or also not participating in these projects, we were arriving at these conclusions that it's just, to the outset for a non-expert, it looks scary, it looks complicated. If you can just spend a few lawyer hours to design nice consent forms, get signatures, that's much easier.
Okay.
Thank you.
Walter Trien, do you share that sentiment that the most businesses will choose the weak pets because they're like uncertain about the added value of more advanced pets? Is this something that you have observed in your practice? I see nodding heads. That's
absolutely. I think the word multi-party already presumes that there are multiple problems, multiple levels, multiple spheres of complexities you have to solve. So it's kind of the complexity is built into it.
So you have to change the name of your technology, guys. This is the message here.
Yeah, but I think it's normal. I don't think it's something we need to be very worried about or afraid about. It can be surpassed. Give it time. It will go away, because as a community grows, community practitioners, of researchers, then I think the information and knowledge about what this technology is about, what we can do with it, it also spreads, and hopefully, maybe another 10 years, if we are patient enough, then maybe in 10 years when we meet up here, we can talk about MPC as a daily practice unit, as a new normality. Mm-hmm. But I think we're getting there. But for the time being, there's a lot of suffering that we have to overcome as lawyers, as cryptographers, as business people. But I think it's part of a kind of a natural technology transfer process. So hang in there, we will get there, and let's discuss how to accelerate this process.
Yeah, we will get to that point. Walter, any?
Yeah, very much so. My experience is that basically at, let's say, the boardroom level, for example, healthcare insurance companies in the Netherlands, and also, let's say, their equivalents in the civil service, and also with healthcare providers at that level, and maybe it's a generational thing, that sounds a bit defeatist, but there's an intuitive reflex to go for large silos, stuff like data lakes. That makes sense to the people. When you talk about federated, decentralized, peer-to-peer data at source kind of concepts, which are much more, with multi-party computation, you're sort of applying all these things. That is new and scary to them, and the ones in that group with the most advanced technical knowledge sort of came of age around the time that SQL and relational databases were the big new thing, and are sort of stuck in that paradigm. So it's like Trien said, partly a matter of time, and also just having successful examples you can point to. Mm-hmm. But yeah, multi-party, but also decentralized and federated, these are concepts that kind of scare them deeply because they have no familiarity with those concepts. So there's a great deal of communications to be had about that.
Okay, thank you. Yeah, so indeed, yeah, communication I think is important. Maybe one part of that is maybe creating a value proposition for MPC. So where would you see the value of multi-party computation, especially given the challenges that the GDPR gives in the area of, for instance, what are the legal grounds for processing, or maybe looking at Article 25 in relation to the application of privacy by design? Is there a kind of like sales pitch that you could maybe build on top of that? Is there anything?
I would say that given the spotty and poor enforcement of the GDPR, at least in the vertical sense, and to go back, there's also horizontal enforcement through basically the European equivalent of class action.
So for the audio, horizontal and vertical, explain please.
Vertical enforcement is typically enforcement by regulatory governmental agencies, like your data protection authorities, like in competition law, your competition law authorities, and so on. Horizontal is between citizens and organizations together. For example, consumer law, you see the consumer organizations often do take legal action against bad players in consumer products. And the GDPR plus additional relatively new European frameworks allow for more what the Americans call class action lawsuits. In Europe we call them collective redress. But that is a mechanism I've still some hope for that will help. But I've sort of lost faith, and that sounds very bad coming from a law person, on the vertical or on the governmental enforcement, especially in the smaller member states. And Germany counts as a small member state since in its infinite constitutional wisdom, it puts the GDPR enforcement at the level of the German member states, which are effectively small countries. So again, you get this scale problem, and with the kind of level of ignorance the first speaker was encountering with, that you required consent for encryption. Well, there's a clear mandate for encryption in the GDPR itself. So all that nonsense is something that is very frustrating. Also, I think the GDPR is flexible enough to not to be an impediment to this, at best a driver for this. The big barrier for acceptance of multi-party computation is typically in healthcare, the healthcare laws. What may help is the European Health Data Space, which is a new European regulation. But again, a lot of that details has been kicked down the alley, and there's additional delegated regulation coming in from the European Commission. And I have not great hopes for that process to have great outputs, but in theory that could be helpful.
Okay, but maybe moving away from the enforcement angle, maybe looking more at the opportunity angle. Is there any specifics where multi-party computation would maybe, allow certain things that would otherwise be harder? I'm looking at Trine and Christian maybe to answer this question.
Yeah, so I mean, from practice, from experience, I can say there's like two directions where you could formulate as a sales pitch for MPC. Indeed, there's examples where you would get utility from being able to share data, but you don't dare to, you don't want to, you're not allowed, either for competitive reasons or for legal reasons. And sometimes having this MPC as a technology as part of the solution can then help to convince data protection authorities to, if at all this is applicable, basically give the green light. But I also would like to mention a second point, namely cases where data is a liability. There's enterprises, organizations that want to provide a service. In order to provide this service, they need to collect data. They even have to accumulate data. But that's actually not their main point. They would like to provide some service. And MPC often can be used to provide the same service without this problematic data accumulation. That's then reducing risk of fines, risk of data theft, hacking, that kind of stuff. And every CEO, every risk manager at a company likes this, and then would happy to buy such a product. Yeah, that's we've seen in practice. Companies having databases, and now with the MPC solution, they can delete this database. Of course, it's then replaced with some secret shared distributed system, where you still have to have some assumption about the trust, but it's way easier to handle than such a central database.
Thanks. See?
And if I can add, then maybe what I find very interesting is that multi-party processing is, by the name itself, it enables so many different use cases. On the one extreme, you can produce statistics, so you can aggregate lots of information based on individuals. On the other extreme, you can find out people who invade paying taxes, for example, in Cybernetica's case, another one practice from 2015. So you can single out individuals who are doing bad things without doing harm to innocent people. But in both cases and in both examples, you can still focus your attention to what is important. So you can filter out important information from a lot of unimportant information, and do so without overly using people's personal data. And I think that's one of the key functionalities of MPC. It helps you focus on the important stuff without overly processing data that is not relevant for your purpose.
So it helps for the minimization, data minimization.
Yes, exactly. We call it data minimization as lawyers.
Yeah.
But I think terminology is important. I mean, choice of terminology is important depending on who you're addressing. If you're talking to lawyers, yes, talk about data minimization and all the protection measures and all that. If you're talking to business people, different terminology should be used. If you talk to cryptographers, then the best terminology here. But yeah, audience is important, and the choice of words in marketing as well.
Thanks. Walter, in your introduction to the GDPR, you mentioned these different legal grounds based on which you are allowed to process personal data, and there's many. You mentioned consent, maybe overrated. And one interesting, actually the last legal ground is legitimate interest. And I think you already mentioned there that there's a kind of like balance between, on the one hand, the interest of what in legal terms is called the data control, let's say the business, and on the other hand, the protection of the data of the data subject. Could we perhaps argue that applying multi-party computation and probably also other privacy-enhancing technologies might help invoking the F ground, the legitimate interest ground, more easily for processing personal data, or is this not as clear cut as I, as a poor computer scientist, make everyone here believe?
It's kind of funny, though. By the way, of course, it's not as clear cut.
He's a lawyer, huh?
Yeah. Well, if I may make one remark, which is entirely beside the point of this question, it's kind of funny because to us lawyers, the question whether data is anonymous or not is an entirely binary question. Mm-hmm. Whereas I get the impression among cryptographers, anonymity is kind of a gradient. So sometimes we have the reverse experience. But to get back to your question,
we have k-anonymity,
yes,
for instance.
The answer is the legitimate interest as a basis for processing is kind of a basis for a last resort. It was meant for that. It's not being used as that, mm-hmm. But it is not. It's for a reason. It's at the bottom end of the list from A to F. It's one that is used very often and quite often legitimately, but it's also abused a lot of times. And the data protection authorities do not have a very positive outlook on it in a basis. I think for private actors, both consent and the execution of a contract with the data subject, typically are more, especially execution of the contract can be a pretty comfortable basis for processing. You still have proportionality questions. But all that said, indeed, that balancing act is helped by use by multi-party computation. If you look at those who really need to enforce their case for that balancing act, you tend to end up in places like AdTech, where the balancing act is kind of completely out the window for starters. If you're looking for interesting use cases where this is going to be helpful, I would say build interesting use cases like congestion pricing, like smart metering.
But you're saying something interesting here. Like if you would consider ad technology, you would say independent of the advertising online. You say basically independent of the technology that is out of the window. You want to do legitimate interest. But if you would like hypothetically speaking, be able to do fully privacy-friendly advertising based on MPC, would that not wouldn't you be able to put that under legitimate interest? Or
it's not the advertising what's the problem there. It is the third-party tracking, the surveillance-based, the behavior-based advertising. If you were to use multi-party computation, for example, contextual advertising, mm-hmm. that might be an interesting use case. But that ecosystem is kind of has painted itself in a corner in which, and that's the interesting case where you see why regulation actually can be a good thing, because if regulation is not there or completely ignored by poor enforcement, it doesn't pay to be a good actor. So you end up with an ecosystem that almost solely consists of bad actors. And there's billions involved. And the first one who actually moves towards contextual advertising will have to tell their shareholders, we have to accept a lower profitability. It will
Although this depends a bit on the use cases, right? Because there have been stories where certain companies have said that even contextual is better than targeted.
Yeah.
We have experiments, but yeah.
Yeah, and now that there's a slight uptick in enforcement on the bloody cookie banners, which are entirely can of worms on their own, it turns out there's about 40% that always clicks no and reject, and it turns out to be the higher income, higher educated people that actually you as an advertiser want to reach.
Thanks. Yeah.
Yeah.
Trine, any further reflections on this topic?
I'm not much into advertising world, and I'm the person who clicks no every time. So I don't know if it works, but at least I do that out of habit. But I just want to remind as well that legitimate interest ground does not work for public authorities, and this is something to keep in mind when you are looking for a legal basis for data processing for public good purposes. Then you probably have two options only. It's consent or law, and that's it.
But then still, probably by looking at the Article 25, privacy by design, or all the security requirements in Article, what is it? 32. Would, in those cases, MPC would be something that is useful in order to make your case that you're more or less compliant to the GDPR. Would that make a difference?
I think it depends how we model this use case or this processing, because if it's really input parties and output parties who are both joint controllers, and one of them is public authority and the other is non-public, then perhaps the public authority can rely on some legitimate ground or legal ground other than legitimate interest, but the private party might be able to rely on legitimate interest. I have not used that myself because I find it a bit explosive, and usually there are other grounds. But again, it really much depends on what data you are using, in what context, in what field, and what purpose. So it's not rare that even the private party also has another legal basis to rely on.
Okay. One thing that I noticed also during the morning and the presentations during this whole workshop is that there's all these different kind of models underlying secure multi-party computation, the adversarial models, the deployment models. When I hear you as lawyers talk about the topic, I get the sense that these kind of like subtle distinctions don't really matter that much in the legal analysis. Am I right? And am I shattering any future research here in the process? I don't know.
I think we are yet to get to the point where we need to, we as lawyers are able to put it into context. Because for me, when you say things like active security module or passive security module or semi-malicious or semi-honest and things like that, and I always get confused. I have to think a lot before I say something. But I have good colleagues, Riva and Dan, who usually are offering their helping hand at that point, and if they translate what is being said, then I can hopefully reply in a legally adequate manner as well. But I think it takes time to really adopt this language and understanding of cryptographers, information security engineers, for lawyers. It's a different realm, and it takes time to really switch from legal to technical and vice versa.
I would say this question is not new to this in general. For example, if you end up in front of a judge because a doctor amputated the wrong leg, you needed to go to hospital for a leg amputation. I hope it never happens to any of us, but these things happen, and then it sometimes happens that in the process there's a mix-up and the wrong leg gets amputated. So you end up with 2 amputated legs, and people tend to be even less happy than with just 1 amputated leg, as you can imagine. And then the typical question is asked, there was a mistake made, of course, but mistakes get made. And then basically a bunch of other doctors will called into the courtroom and being asked, would a reasonably acting professional in this field have acted in a similar manner as this particular doctor has? And depending on their answer, it will be basically an assignment of damages and so on.
Mm-hmm.
And you will end up in the future in similar conversations on, for example, you apply this and that protocol, and was that the appropriate protocol? Were these the appropriate technical measures, and in the light of the risks and what was available and the cost, etc. And there will be a bunch of expert witnesses called in.
So it's part of the risk assessment, basically. That's what you're.
I'm saying that the law people have to deal with lots of highly domain-specific knowledge, and for these ultimate questions, you ask the domain experts what would be the normal thing to do in the case at hand, or the proper way of handling that, because we are good at interpreting texts and helping out with resolving conflicts. But ultimately deciding what protocol should have been used, or what steel should have been used by building that ship that sank, or what leg to amputate, that is for the experts in those fields.
I see.
Maybe just throwing in one thought here. Makes all sense what you're saying. I can imagine it's also the fact that these nuances are sometimes lost when it's treated by. Let me simplify this by saying the legal side, but actually it makes a huge difference. Even let's say the least secure MPC protocol is still way better than a plain commutation. So this is the biggest step, at least I think in my mind, and maybe you agree. And that's why these nuances are then much later in the process becoming irrelevant, perhaps.
I think that's a fair statement. I think it's nice also maybe to open the floor to questions from the audience. Do you still have a microphone, or should we share one of the microphones from the panel for that? Yeah. Are there any questions? There's this famous saying about are there any questions that you were afraid to ask about the GDPR? Now is your time to do it. Everything you wanted to know about.
We have one hand already here.
Oh wow, fast.
Thank you. So you were just talking about the difficulties of sort of translating technical assertions of MPC protocols into the realm of law and regulation. We kind of go in the other way. The literature will just assume non-collusion between protocol participants. Does the law regulation, is there any precedent for trying to, substantiate this notion of non-collusion? Like, how would two entities doing MPC together prove to a regulator that they have colluded enough to deploy something, but no further?
You want to take that, Trine?
Yeah, I can do the introductory. So 10 years ago, remember I mentioned in the beginning this project called PRIST. We had in Cybernetica, and that was a case where we consulted. It was a research project, right? So the end result was generating statistics by means of MPC. But we were required by that, back then, by law, to consult with the local data protection authority if we wanted to process masses of personal data for research purposes, whether it's actually legal to do so. And then when we did, then, after months of back and forth and explaining the technology and all that, and in the end, the DPA came back with a resolution that in this specific case, no personal data was being processed, provided under two conditions. And one of the conditions was, the first one, provided that the parties do not exchange the same data outside MPC at any point in time. And the second condition was that none of the party gets access to the source data during the research project. And I think these are quite, back then we thought, okay, wow, we're doing anonymization, excellent, no need to think about data protection law at least. But of course it felt a bit weird. Until now we are seeing new kinds of interpretations like the one introduced by Hendrik Bolhausen from LMU with the clinical data where law firms are already advising to interpret use of MPC as pseudonymization, which means that it automatically falls under GDPR, which means that you don't have to feel weird that you're kind of as if not processing personal data at all. But I think the learning point for me as a lawyer from that case was that you can do all the tricks you want with MPC. If the parties find a way to exchange the same data outside MPC in any other context, even just on paper, then it all blows up. And how to really address that, technology does not provide answers here. And this is where you really have to weigh the economic interests, organizational setups, and other circumstances. And I think it's a really huge and difficult question to solve. Thanks.
Thanks.
More questions from the audience?
I think Walter wants to maybe also say something.
To go back to the non-collusion, the law does not say anything, but as Jean said, if you look at the incentives of the parties involved, then you may or may not be comfortable. I would be rather comfortable with the application of MPC for medical research between university hospitals, because they still are under medical secrecy laws. They are under the rules for the scientific establishment. As soon as you involve a for-profit healthcare insurance company in that context, then the non-collusion is no longer that credible as it was before. To just give a very concrete example, and then your case may fall apart. So, as Tien said, ultimately, you need more than just the technology.
Thanks.
Yeah, maybe I can also throw in that also more technology sometimes can help. I mean, it is possible to address this collusion assumption somewhat, for example, by linking potential collusion with economic stakes. So it may not be preventable to have collusion, but if it's detected, then maybe automatically some stake is slashed, a fee is paid, and that's an additional way to deter collusion, for example.
Mm-hmm. True. Any more questions from the audience? I think they all understand GDPR and MPC perfectly. There's a question there.
I think I have a question that's like tangential to what was just discussed. Does the GDPR, or how does the GDPR handle the cases where some of the participants are outside the European Union? So, for example, like the first talk in this track, you mentioned that in the future it will be great to go transatlantic, and then the model that they're running is, I'm very sure, is like a three-party with one corruption, meaning that two of the parties can reconstruct the data. And now that's a big question. If you put one of these parties, across the pond in the US, and now it means that the parties in Europe can reconstruct the US's data, or if you put the third party in the US, now the US parties can reconstruct the European participants' data. Does the GDPR, say anything there, or is this one of these, it's a case analysis, or you have to analyze the case?
Well, it is kind of funny because we discussed this question before the panel, and we all agreed that we didn't want to open this particular can of worms. But
he did it. It's his fault.
To get into our jargon, Chapter 5 of the GDPR, which treats third country transfers, has as a rule, thou shalt not transfer. And third countries, in this respect, by the way, should be understood as countries outside the European Economic Area. So EU plus Iceland, Norway, Liechtenstein, and Andorra. Often forgotten for reasons that are not obvious. The thing is, I would agree with our Austrian or Bavarian first speaker. Your typical analysis is that even with multi-party computation, the data is pseudonymous and not anonymous typically. So you're still transferring personal data, so you fall full underneath. The positions of the DPA so far has been that the use of cryptography, especially strong cryptography, may be a safeguard in this regard. But you specifically mentioned a country with an outsized power in terms of crypto analysis and compute power involved. That should also be taken into account. You're also mentioning a jurisdiction that whatever safeguards for privacy and data protection that are there are under erosion at the moment. That's also something you have to take into account. The current available legal instrument is sort of a zombie one because it has been struck down twice already, and the third time is most likely going to happen in another year or so.
You talk about the privacy shield here, right?
Yes, well, the current data privacy protection framework, I think it's called.
Okay. Well,
Yeah, that's a
okay.
safe harbors, privacy shield. They die so easily. They get schramscht. So then you rely on the so-called contractual clauses, and the standard contractual clauses require you to make an analysis on the likelihood, specifically of the likelihood of intelligence services of the receiving country abusing their powers to get into the data. I'm sorry, but it does not look like we are friends anymore. So I would not advise in favor of it.
Yeah, this is a bit tangential, but it brings up, Walter, you bring up a good point here, namely the fact that in other areas of security, cybersecurity, cryptography, we have this way to observe degradation of security relative to computational capabilities or cryptanalysis. And that's something we don't have in MPC yet. I mean, as an example, the ES block cipher used for encryption globally for more than 2 decades already. It is possible to, well, there's actually two things. One is just Moore's law or similar increases in computational capabilities that reduce the security by like half a bit or 1 bit per year. That's relatively easy to observe. And then there's also cryptanalysis. And in many cases, like in this AES case, it's nice to observe this, and it's possible to observe this progress in cryptanalysis over the years and decades. So whereas in the end of the 90s, the best attacks, even in esoteric settings, were like 6 out of 10 rounds. So this gives security margin. And then you can observe 5 years later, there were the first attacks on 7 rounds. Again, very esoteric settings, but still. And even now, our best attacks on 8 rounds are super marginally better than brute force, and this is now 20 years later. So you have like early warnings as to when maybe the actual fully used version is affected. Well, the good news is in MPC protocols, some of them actually are not affected by any of those two, in case we are thinking of information theoretically secure protocols. So, but of course, this shouldn't be understood as this is magic dust and whatever we use it's secure. There's other families of MPC protocols where very similar cryptographic primitives are used than this AES thingy, for example, and where we have this infrastructure to observe this degradation of security. And it's there, actually. We just don't communicate this. And I can imagine, especially for people outside of cryptography, this way of communicating about security is something that would increase trust.
And if I may add, maybe back to the question asked regarding data transfers to countries across the sea, the Data Protection Authority in Europe has been kind enough to actually provide some guidelines on under what conditions could you presumably securely transfer data, for example, to US territory. And I think it's a very practical question because, of course, we use a lot of cloud services, you know, Amazon, Microsoft, Google, the usual suspects. And when we look at these guidelines, then there are 6 conditions which the European Data Protection Board has proposed under which it could be secure to at least host maybe 1 share of the MPC in US territory or in US-owned cloud infrastructure. And one of those conditions is active security model, I've understood, so that you have to be at least, you have to withstand at least one, well, how is the correct word to phrase it? So you have to, even if you have even one honest person in the MPC setting, you're still safe if you have 1 share stored in US cloud. Is that what I take from it, more or less? So, but that's only one of the 6 conditions, and I would say the rest of the 6 conditions are rather restrictive, and I think it's, even under current technology circumstances, it will be quite hard to meet those 6 requirements. But the good thing is that the Data protection regulator is thinking about it. It's providing public guidelines about it, and it's actually the first document mentioning split or multi-party processing as a potential security measure. So that's a lot of acknowledgement to your work as a community, as technology providers. But at the same time, it again spurs new discussions, especially in light of today's political circumstances, whether this guideline still withstands the new circumstances.
Yes. I think, any more questions from the, all the way in the back, very good.
Oriana.
Hi, I heard mentioning that data in MPC might be considered pseudonymous. Maybe I'm kind of getting it out of context, but I was wondering, what about a case where the anonymization process is run in an MPC protocol? Is there a way, an interpretation that considers this whole process anonymous? Because it becomes kind of a challenge when the interpretation, sometimes that comes from the legal side, is asking, what about the inputs? We're trying to enforce the anonymization on the inputs, and then you can do whatever you want with your MPC. But this oftentimes kind of loses the whole purpose of the protocol. So I was wondering whether you have encountered this and whether there is a way to kind of do this anonymization labeling when we have this composition.
Thank you for that questions, and since I have the microphone, I'll start.
You do it.
I think, so you are basically asking if you're doing anonymization with MPC, could that still be considered as processing personal data under GDPR, right? But the purpose of your processing is to make data anonymous.
Yeah, whether we can consider kind of the whole process to be anonymous, right? There is a way where I take my data and I apply the anonymization process locally, and then everything is anonymous, and that's more of a clear cut. But what if the anonymization process is me and you running some MPC protocol that, according to the cryptographic kind of guarantees, we know that we learn only the output, and the output on its own is anonymous. But everything that happens before that, as a cryptographer, I know what happens, but from a legal perspective, I still struggle to understand what happens.
Yes, I think all lawyers, and me included, have been struggling with that for the past 10 plus years. But I guess the answer starts with declaring again that it all depends on a use case, as Walter already established in the beginning. So, for example, if we take a statistics use case, let's imagine an official statistics use case where the whole goal of data processing is to make statistics. So statistics should be, by default, something that is anonymous or something that is de-identified already. So in that type of use cases, I would imagine it is possible to do anonymization by means of MPC, but not only MPC. There's a lot of other things you have to consider as well, because even if a statistics authority collects, they have authority and authorization to collect personal data just for the purpose of making statistics. But they always start off with personal data, because this is the starting. I mean, you can't do statistics from anonymous data. It doesn't make sense to my mind, at least. Otherwise, you couldn't filter out any valuable information from the raw input data. So I think, in principle, in theory, I would say it's possible. But now there's a lot of discussion around. So what is the level of or what is the strength of anonymization? What is the technology and means we are using there to ensure that the final result is de-identified? But I think the beginning starts still with personal data, and the curious thing about GDPR is that it considers anonymization also as processing personal data, because you start with personal data and end with non-personal. And in that case, you still need legal basis. You still need somebody to control the process and be responsible and accountable for the whole anonymization process. You still need to apply technical and organizational protection measures and all the rest of the GDPR requirements. But there are some exceptions, at least for statistics, a special regime. So there are some tools how to facilitate the whole process. And I think in the end, we'll figure it out.
It's time to wrap up. 1 more minute. Closing statements, starting with Christian and then going back to here. Anything you would want to give the audience in the last minute of this panel? Or
Didn't prepare.
I think they are heavy overfed them already, you think?
Yeah, I think, I mean, MPC is something that is developing since the 1980s, and it feels like, of course, we only know with the benefit of the hindsight, but it feels like this is now the time where things will accelerate. Also, as an example, with this starting of this workshop here. So I think it may well be that we are at the right place.
Good. Trien, any final words?
I'm hopeful. With your help, we will take MPC to where it belongs, to the right stages and to the right use cases. But hang in there, it will take some time.
But that probably means involving not only the people here, the technologists, but also the legal people and maybe also the society and the use case providers, let's say.
At least 3 legs, if you use your analogy.
I am also hopeful, but I will also toss out a word of warning. I heard several speakers refer to blockchain or distributed ledgers as part of MPC protocols. I would not say that distributed ledgers, including blockchains, are a priori irreconcilable or incompatible with the GDPR, but they may be in the vast amount of cases. Be very, very careful and think this through as soon as you involve concepts like blockchain.
I can only second that. Thank you, Walter. I would thank you for your presence, attendance, your questions. I would like to thank my panelists for their discussion and answers to your questions. Thank you.
Yeah, and on behalf of the MPC Alliance, I also want to thank you. So Christian Rekberger, Trien Seel, Walter van Holst, and Jaap Henk Hoepman. And before we go to the coffee break, but let's first applaud.
One more time.
Once more.